Good evening, everyone. Welcome, everyone, to this special Brennan Center event, co-sponsored by the Society for Historians of the Early American Republic. For those of you joining us for the first time, the Brennan Center is a nonpartisan law and public policy institute that works to repair, revitalize, and defend our systems of democracy and justice so they work better for all Americans. I'm Tom Wolf. I'm Deputy Director with the Democracy Program here at the Brennan Center, and I'm pleased to welcome you to the kickoff for the first public consumption of a new Brennan Center project. The Brennan Center is teaming up with historians to analyze the US Supreme Court's increasing reliance on history to reverse long-standing precedents. We're talking critical precedents here, like Roe v. Wade, or the long-standing understanding of the Second Amendment. When the Supreme Court gets the facts wrong, we're going to fact-check them. We're also going to analyze the court's increasing reliance on the ideology of originalism, particularly promoted by Justice Clarence Thomas as the one true way to understand the Constitution. And we'll explore more intellectually honest ways for history to impact the law. Before we get started, though, just a few housekeeping notes. First, folks who use rude or intemperate language in the chats, whether it's on Facebook or on YouTube, will be removed from the event. Live closed captioning will be provided. I would remind folks to please sign up for our email list, which you'll see reminders about over the course of the evening. You can follow along on social media using the hashtag Brennan Center Live. Now on to today's program. I'll keep my introduction brief because I am the least interesting person that you're going to hear from tonight. We have a panel of top flight historians who are at the absolute top of their game right now, and they're being joined in discussion by a true icon of contemporary journalism. So I'm excited to pass the mic to our moderator for the evening, the Atlantic's Adam Serwer. Welcome, Adam. We're excited to have you here.
Thank you so much, Tom, and good evening to everybody. In its last two terms, the U.S. Supreme Court's conservative supermajority has overturned long-standing precedents affecting abortion, affirmative action, and gun control. Each time, the court justified its decisions by appealing to what it called the country's history and tradition, or constitutional history. The court said that today's law cannot go beyond the laws on the books, or at least the court majority's characterization of the laws on the books at some point in the deep past, in the founding era, for example, or during Reconstruction. If we want to understand what our rights are now, the court says, we have to look at what our rights were then. The court has sent a strong message that history is going to be the measure of our rights going forward, or at least its version of history. And that has big implications for voting rights, privacy and reproductive rights, climate change, and many other values and policies that are critical to hundreds of millions of Americans. By invoking history so heavily, the court has also put the work of professional historians right in the middle of this crisis. Luckily for us, these historians have a lot to say. Where does the court's fixation on history come from? Is it getting that history right? And with what consequences? Can the court even claim to be doing history at all? We are thrilled to have a panel of expert historians to help us unpack these questions. We have Laura Edwards, the class of 1921 bicentennial professor in the history of American law and liberty at Princeton University. We have Kate Masur, Board of Visitors professor at Northwestern University, and Karen Tani, Seaman Family University professor at the University of Pennsylvania Law School. Welcome to all of you. Karen, it would be great to start with you. As our resident historian / law professor and someone with her finger on the pulse of legal history, I'm hoping you could shed some light on the basics of originalism. When we say the court is originalist or issuing originalist opinions, what does that mean?
Thank you, Adam. And I'll just say, I thought your introduction did a pretty nice job of setting this up. So originalism is a theory of constitutional interpretation that urges judges to ground their decisions in the original meaning of the text of the Constitution. So it envisions a sort of like time zero, at which point the meaning is fixed. So, for example, if a court is interpreting a provision that was part of the original Constitution of 1787, originalism would direct courts to focus on what the public understood that provision to mean in 1787. Similarly, if a court is interpreting the 14th Amendment, which was ratified in 1868, then the court, according to originalism, should look at the meaning of the amendment's text in 1868, and so on. So applying the theory is essentially a backward-looking exercise. It supposedly constrains judges. We can talk more about whether it does that. And it supposedly prevents them from importing their own values and preferences into this foundational text. So when we say that the current Supreme Court is originalist or issuing originalist opinions, what we mean is that they are leaning heavily on that theory or style of interpretation, and they're often treating other modes of interpretation, which themselves have quite long histories, as illegitimate. So within the current court, there are obviously, I think, variations on how committed certain justices are to originalism and how sort of pure they are in their decisions. But I think it's fair to say that a majority of the current court is quite friendly to this theory. I can't quite hear the question.
Has originalism always been how judges understand the Constitution? If not, why are the justices turning to it now? And one more, I hope you don't mind me asking this adding this third question here, but is originalism a recent doctrine or an old one?
Yeah, and I love the way that you phrase that, because I think we could say if you look at the long sweep of the court's history, it's actually not uncommon to see decisions that looked to the original meaning of particular provisions and that tried to honor those meanings. So Justice Hugo Black, for example, who joined some of the most liberal decisions of the Warren Court era, he was quite famous for trying to adhere strictly to constitutional text and for really caring about the framers' intent. But I think today's originalism, I think most people agree that it has a different pedigree. So most scholars date today's originalism to around the 1980s. The seeds of it can be found in legal scholarship from the late 1970s and early 80s. It was a kind of a branch of scholarship that was trying to critique the alleged activism of the Warren Court and trying to offer a more constraining mode of interpretation. And then the real flowering of modern originalism came when lawyers in the Reagan administration, most notably Ed Meese, realized how well originalism fit with that administration's conservative goals. So as Attorney General, Meese famously made originalism the official policy of the Department of Justice, meaning that the DOJ would actually push originalist interpretations in court in their briefs. They even undertook their own originalist research projects. I think also clearly relevant was the rise of the conservative legal movement around this same time, with originalism as a key plank. So as conservative groups like the Federalist Society became more involved in judicial selection, a commitment to originalism became an important sort of litmus test for potential judges. As for, I think, why some justices are turning to it now, I mean, one answer back to what I said about this history is that originalism was sort of central to their ascent to the court, right? They wouldn't be on the court if they didn't subscribe to this theory. But the other reason, and I think this will come up in conversation a lot, is that originalism has turned out to be a tried and true vehicle for undermining or overruling constitutional precedents that conservatives don't like. Many of those disliked precedents have to do with using government power to solve big new problems or ensuring that members of marginalized groups are included. So if you go back to a time when those problems and those populations were not so much on the radar, you sort of stack the deck in a particular way. But at the same time, originalist as a method, it gives decisions a kind of sheen of legitimacy, even when they dramatically change the law. And that is because, again, it's a mode of interpretation that seems to be deferring to the will of the people at these really foundational moments.
Thank you, Karen. And I think, as her answer just showed, this isn't an academic debate. It's playing out in case after case coming before the court with some very real consequences. For example, just this past term, the court struck down Harvard and UNC's affirmative action programs on the grounds that race-conscious programs like their admissions programs violated the 14th Amendment's commitment to what it called colorblindness. Now, that phrasing is not exactly in the 14th Amendment. And in fact, during the debates over that amendment and the laws that followed, lawmakers were very clear that their remedies for the aftermath of slavery were race conscious. So I found that particular conclusion baffling and somewhat at odds with the tenets of originalism as it is generally presented. Kate, you led a group of historians who wrote a friend of the court brief for these cases. Can you explain some of the problems with this colorblind constitution concept as a historical matter?
Yeah, thank you so much. So the question of, when we look at the 14th Amendment from an originalist perspective, as Karen described, looking back to the years like 1866 when it was passed by Congress or 1868 when it was ratified, what do we see in terms of the question of did people at the time, particularly those people who supported it, did they subscribe to what people now call a colorblind interpretation, the idea that everything that falls under the 14th Amendment needs to be essentially race neutral. And if we really go back and look at the history, it's a big problem for originalists like Justice Clarence Thomas who seek to overturn affirmative action because the evidence simply isn't there for them. And so in our amicus brief, we just put forward a lot of evidence from basically the 39th Congress, which was the Congress that passed the 14th Amendment, as a way of explaining that the very same people who argued for the amendment, who passed the amendment, were also passing laws and pushing for laws that were explicitly race conscious. And so there are a lot of ways to talk about this, and there are a lot of ways to kind of answer some of the arguments that it was actually Edwin Meese, the former Attorney General in the Reagan administration, who submitted the most the originalist amicus brief on the other side. So we can talk directly about how we sort of answer their arguments, but let me just sort of give two examples from our brief. First is the Civil Rights Act of 1866, which was passed at essentially the same time as the 14th Amendment, was an explicitly race-conscious federal statute. It's the nation's first federal civil rights law. And it explicitly says that all people of all races and colors should have the same rights as white people. So this first federal civil rights law does not say there shall be no discrimination based on race. It says, it acknowledges that there has been race-based subordination, and it says all people are entitled to the same civil rights that white people enjoy. Another example is policies related to the Freedmen's Bureau. So the Freedmen's Bureau was an agency set up by Congress first in 1865 and then kind of authorized in 1866. The Freedmen's Bureau was designed to provide relief of various kinds to both African-American people and white people, but on different terms. And so Congress explicitly made a distinction between the benefits that white people were going to receive and the benefits that Black people were going to receive. And Black people were going to receive more benefits, less qualified benefits, and in particular, the benefits associated with education. Now, it's called the Freedmen's Bureau, and we can go into a kind of whole thing about whether freedmen is a racial category or a status category. But the reality is these policies were designed for African-American people, whether they had been enslaved in 1861 and were freedmen, or whether they had been free when the Civil War started. They did not discriminate or kind of make a distinction between people who had been enslaved and Black people who had been free before the war. The final piece of evidence that I want to provide is that some people really opposed these race-conscious ameliorative policies at the time. The president of the United States opposed them, Andrew Johnson. Some Democrats in Congress opposed them. They used arguments that are very familiar to us now. These policies give unfair special favors to Black people. These policies discriminate against white people. And the reality is the people who supported the 14th Amendment outvoted the people who opposed it, who said these were race unfairly discriminatory toward white people. President Johnson vetoed the Civil Rights Act of 1866. The majority in Congress overrode that veto, saying, no, this is what we want. So the arguments that we're familiar with now about the notion that any kind of race-conscious ameliorative policy is discriminatory toward white people were around then, and those arguments were defeated at the time. I mean, the bottom line is these people were not making policy in a vacuum. They weren't theorizing about race blindness and color blindness. They were trying to deal with the problem at hand, which was the abolition of slavery and how to create a multiracial democracy.
Yeah, I mean, I think what struck me about that opinion was the extent to which it was projecting backwards through time a presentist conservative understanding of what colorblindness means onto people who obviously lived a century and a half ago and did not have that same, were not in that same context. The Supreme Court has issued other recent opinions that roll back important rights by appealing to history that might be questionable. We can just look back one more turn to the court's opinion in Dobbs, where the court eliminated the federal constitutional right to an abortion. Kate, can you give us a little bit of detail into the problems with the history that was cited in Dobbs?
Sure. The Dobbs decision has different issues in terms of history. One of the problems, or the court majority in Dobbs, is basically one of the core arguments there is that right at the same time that the United States was adopting the 14th Amendment, states were passing a wave of laws that criminalized abortion from the earliest beginnings of pregnancy. So there's an incompatibility that the court majority opinion observes between the 14th Amendment, or the interpretation of the 14th Amendment to include a right to terminate a pregnancy, and the reality that at that same moment that the 14th Amendment was ratified, all of these states were criminalizing abortion. So the court is not factually incorrect on that, but the decision is leaving out an enormous amount about the history of the mid-19th century. The opinion has no room to ask who was driving the criminalization of abortion. Was the fact that that many states adopted new anti-abortion measures in the mid-19th century, was this a widely popular program? Were the new laws that increasingly criminalized abortion widely enforced? And as historians have investigated these questions, they've found that this history is very complicated. There were a lot of doctors associated primarily with the AMA who were very interested in criminalizing abortion. But when it came to actually prosecuting people for doing abortions that were now against the law, there weren't as many prosecutions as you might think. Juries were not very interested in convicting. Women continued to seek pregnancy terminations and to get them even as these statutes were passing. So there's a very mixed picture that doesn't come through at all when all you do is look at what state statutes were doing. I'll just add, I mean, there's so much more that could be said, but when we're talking about the history and traditions of the United States, it's very interesting in the Dobbs decision that the history and traditions of the last 50 years are completely left out of the majority opinion. So we conveniently go back and look at a time period when women did not have the right to vote, when there was not nearly the kind of critique, a successful critique of patriarchy that we have seen since the 1960s and 70s at that time. So it's very convenient to go back and say, well, the history and traditions in the 1860s don't support it, when we actually have had until 2022, 50 years of a constitutional right to an abortion. That history and tradition is kind of completely ignored and neglected by the majority of decision. It's a thing that the dissent tries to bring back into the picture as another valid aspect of American history, but it's entirely written out by the majority.
Yeah, the founders actually had a very sensitive sense of privacy when it came to intimate matters, but for completely different reasons, which we don't need to go into here, but I think we all know what I'm talking about. The court's focus on history will take center stage in a major case this term. Zaki Rahimi is a Texas man charged with illegally possessing a gun while subject to a domestic violence restraining order. Rahimi argues that the federal government has no right to disarm domestic abusers because those laws did not exist at the time the Second Amendment was passed. Laura, you've been grappling with the Rahimi case. Recently, you and several other historians filed a brief with the Supreme Court arguing that the Second Amendment should permit the federal government to disarm people in situations like this because of an established history and tradition of restricting dangerous people from having guns. Can you explain where Rahimi's arguments are coming from and whether his attorneys have the history right?
Yes, thank you for summarizing the case so well. So yes, the historian's brief well, actually, the Rahimi brief was, they're making basically two contentions here. And one is that there is not a history of regulating guns in the founding era in the 1790s. And then there's also not a history of disciplining domestic violence offenders, that essentially that is something that is very recent. And so there's not anything analogous in the founding era that provide any way of regulating either guns or addressing domestic violence. And the historian's brief was saying that actually both of those contentions are wrong. That first of all, there is rather a robust tradition of regulating guns. It's just that it doesn't happen in the places where the court has been looking. And so to echo what Kate was saying, most of the time people are looking at statutes. And when you look for statutes on regulation of guns from the 1790s, the late 18th century, early 19th century, you don't find that many, actually. I mean, they are there, but there's a smattering of things, and they're regulating particular kinds of groups, and it doesn't all really seem to fit together. And so if you look at that, then you say, oh, look, there's no regulation of guns, and therefore individuals each must have been able to possess guns and do whatever they wanted to with guns because there's no statutes on them. And what the brief argues is that that's actually the wrong way to look at this, that in fact, states at that time stayed out of a lot of issues relating to the public order, and regulating violence in particular was one of the things that they stayed out of and tended to give to local communities and local jurisdictions instead to regulate. And then a lot of those local jurisdictions were not issuing ordinances or written documentation, that they were following common law in its unwritten, assumed form. Common law in this more capacious idea of what common law is, not as written down in treatises, but as basic principles that are well understood and therefore don't need to be written down at all. People just followed them. They were assumed. And one of the assumptions is that everybody in a community has the right to be safe and to feel safe as they're walking around. And so if you felt endangered in any way, you could go to a magistrate and say, look, I feel in danger. And then the magistrate would step in, issue a peace warrant, and then bring a person in who was seen as being the offender, who was potentially violent, and put them in jail or have them post a peace bond, where members of the community would come in and post money on the promise that they would watch that person to make sure that they did not offend again. So what was happening here is that the guns weren't taken away, but the person was separated from the guns or whatever kind of instrument of violence that they had. So you're not going to find statutes of that. A lot of this is then actually in local communities, local jurisdictions, local court records that are very difficult to access, but together constitute understandings of how things were regulated in this period that extend way beyond the written documentation that we ordinarily use. And then the second point is that domestic violence is regulated in much the same way. There is this presumption now that somehow we weren't regulating domestic violence until second wave feminism in the 1970s. And yet in the founding era, domestic violence was regularly prosecuted, not as a violation of the women's rights, but actually a violation of the public order. So women, married women under coverture, did not have the ability to file cases in their own names, but they would go make a complaint, and then the magistrate, local officials would then proceed with the case as a violation of the public order. Marriage was seen as so foundational to the public, to society as a whole, that it was not seen completely as a private institution, but rather as something that deserved public regulation because it was so foundational. You could not condone terror in the heart of what was a central institution to society as a whole. So it wasn't as private institution, it was seen as fit for public regulation, and the authority of husbands was always checked because it was granted at the behest of the public order, and when it violated the public order, then the public had a responsibility to come in and do something about that. So in both cases here, there is regulation, it's just not where people have been looking for it before.
So, Laura, even if the history is on your side in this case, you see real problems with how the court deals with history. Can you explain what some of those are?
Well, yeah, in this instance, it seems pretty clear to the historians that the history is on our side here. Regulation of both violence, including separating violent offenders from their guns. And by the way, when you go to jail, you can't take your gun there in the 18th century. So they didn't take away the gun, took away the person from the gun. Gun stayed home, person went to jail. So there's a separation there. But there's also in this period, you're regulating in the public order, in the name of the public order, right? So women cannot, in this period, married women cannot institute cases in their own names. They have to do this in the name of the public order. The public order itself was then also constituted around incredible inequalities. It sanctioned coverture and the subordination of married women. It sanctioned slavery. It sanctioned all sorts of restrictions against people without property. The vision of the public order here was really unequal and really problematic given changes in our society now. So while we have this robust idea of public regulation, it is also, if you take it literally from that time period, a kind of public order that we would not actually sanction today or want today. And it also is a public order that sanctioned the denial of rights. And now we have a legal system and a legal order where rights are really crucial. So taking us back to a period where most people don't have rights, when we're living in a world where rights are so important, is really a problem.
Thank you very much, Laura. Karen, we've been focused on what the court's originalist term means for individual rights, but it also poses a threat to the federal government's ability to carry out basic responsibilities. This term, there are several cases that are challenging the power of federal agencies, continuing a trend of originalist attacks on the administrative state. Can you explain the thrust of these attacks and the problems they pose?
Yeah, thanks for this question, Adam. The first thing to say is probably, disaffection with the administrative state is obviously nothing new, but this is one of those arenas where the composition of the current court has emboldened some longtime critics and presented some great opportunities. Some of those critics, I think, have genuine concerns about democracy and accountability, but I think many would simply prefer less regulation, and some of these cases are sort of about that goal. The legal arguments that we're now seeing are, many of them are based on the idea that today's administrative state violates the separation of powers that was so crucial to the original Constitution. So the argument goes, legislation is supposed to happen via the legislature, but too often today it instead happens via bureaucrats who are unaccountable to the people. Similarly, the argument goes that too often today courts simply defer to agency judgments. So this is the problem that some critics have with the Chevron doctrine, which the court is poised to reconsider this term. For similar reasons, critics have opposed agency structures that insulate agencies from presidential control. So these are structures that Congress clearly wanted and that are crucial to the mission of certain agencies, so like the Consumer Financial Protection Bureau, the SEC. But again, critics see a conflict with constitutional design. In terms of the problems with these challenges, I think there are a number of things to say. So some scholars have made arguments on originalists' own terrain and pointed out that this country has long had an administrative state, including robust delegations of power to agencies. So yes, today's administrative state does much more than it used to, but that does not make it unconstitutional or illegitimate. I think others also make some very good pragmatic points about what it would mean for courts today to radically retrench the role of agencies. So I think to the extent that critics want Congress to do more of the work that agencies are currently doing, I think many people would say that seems logistically impossible. And if congressional incapacity leads to a lack of public governance in areas that need that governance, such as environmental protection or public safety, I think that seems deeply problematic. I think another pragmatic worry is that the court will retrench the power of agencies in ways that aggrandize the power of the Supreme Court itself. And suddenly we just then have a different set of unelected actors, these ones with life terms who are dictating what happens or doesn't happen in important policy areas.
Thank you, Karen. We've been talking a lot about how the court gets history wrong as a matter of fact and why as a matter of policy and principle, the court's reliance on history can be troubling. There's another aspect to this problem that I hope all the panelists can discuss. Is the court even doing history? From a historian's perspective, what's wrong with the ways the court claims to be stating truths about the past? And to be clear, anybody can answer here.
So can I jump in here? I think it's a great question. And, you know, in the earlier period, in the founding era, which has become so important with originalist thought and with these decisions, the emphasis has been, as Karen said earlier, on text. But one of the problems here is in that period, law was not captured only in text. And so you actually have to understand a broader context. You have to understand on the ground how people are creating law through their actions, through court cases and court records, the way that they're bringing cases, making all kinds of claims. There's a whole range of unwritten laws that are out there that I'm having trouble describing to you how you do this, partly because it's so complicated in figuring out what the legal context is when you can't just look at a set of written text. You have to look at actions. You have to look at what is not said, what is assumed. And so that's actually hard to do. It's what historians spend their life doing, sitting in archives trying to figure all of this out. And so when people say, oh, I went and looked at a few statutes and I know what's going on, that doesn't fully capture the history of the time period, and especially the legal and constitutional history of the time period.
Yeah, thanks. I would just add to that one of the things that I see originalists doing, both in the two cases that I've spoken about tonight, both in the affirmative action cases and in Dobbs, is really taking quotes out of context or sort of cherry picking quotes that serve their argument. So, for example, with the question of race and race consciousness and the 14th Amendment, you sometimes have people Republicans in Congress saying that the Constitution should treat everyone alike. And so that's a great quote if you are an originalist who wants to overturn affirmative action. But in the next sentence, that person might have said, but right now we need a Freedmen's Bureau to help freed people get, or, you know, Black people get an education. And so, you know, for most historians, I would dare say maybe all historians, doing history means taking the whole context into consideration as much as you can. And we have a kind of ethical obligation to deal with conflicting evidence, to kind of look at the whole picture instead of taking out quotes here and there. And as Laura just said, I mean, this is a lot of work. It takes a long time to do historical research. It's not the kind of thing that a word search in a digitized text like the Congressional Globe is going to get you. And so, you know, when I keep coming back to, when I think about this question of, you know, are originalists really doing history, I keep coming back to this notion of context and this idea that courts and the law are part of history. They don't stand apart from it. And that in order to really do history around these incredibly pressing issues that we face today, and to really understand kind of where we were, if that is indeed the exercise, what did people think about these questions in 1868 or in the 1780s or 1790s, that there's a whole world of sources that needs to be examined. There are, and that we need to do it kind of ethically and with the sort of idea that we are looking at the whole picture, not just looking for evidence that supports a claim that we want to make. That's very foundational to the work that historians do.
I'll just chime in quickly. I think this point complements the ones that have been made. So one thing that I worry about with historical interpretation as it's done on the court today is the way that it combines with the power of precedent to essentially lock in particular interpretations of the Constitution. So precedent ends up giving historical interpretations a fixity that I think professional historians would never give to their own work. And that's not because we think the past is unknowable, but because we understand that our own views of the past are always partial and imperfect, and maybe some future historian could come along and with a different sources or a different method could produce a different interpretation of a crucial time period or event. So, and I worry about that in particular in areas where the historical record is open to multiple interpretations or where the history has not been well studied by professional historians. So I think in those contexts, it seems dangerous to pick one interpretation and then give that interpretation the status of constitutional law going forward. Another concern I have, I think, is how easy it is for the court to do a sort of like Frankenstein's monster move where they selectively revive pieces of the past and thereby create something troubling in the present. So my colleague Sophia Lee has made a version of this point in the administrative law context, which I was just talking about earlier. So critics of the administrative state are really eager to draw on history to kind of push the administrative state back towards the early 19th century, but without also pushing the court's judicial power back to its more modest early 19th century level. So again, I think, there are reasons to feel uncomfortable with what the court's doing with history.
Thank you very much. We've talked a lot today about, how important it is to view law as something more than just statutes and judicial opinions, which seems like an especially important insight at a time when the Supreme Court is rewriting history. Should the Supreme Court be the final word on our rights and our national story?
So I have a thought here that comes out of working on the Rahimi brief, the historian's brief. And the most difficult thing of working on that brief was trying to convince other lawyers and historians that women, in fact, did challenge domestic violence in the late 18th and early 19th century, and that there was a legal space for them to do so. And this gets to me, for me, a really big, important point about our constitutional traditions, our legal traditions. And our legal traditions are not just from legal professionals. They don't come just from legislators and judges and even lawyers. In the late 18th and early 19th century, there was space in the institutional systems of governance for ordinary people to make claims that had real legal purchase that then became enforceable law. And so when a woman, and this to me is really important, a married woman who had been beaten, she didn't think that was okay. There was space for her in the system to challenge the authority of her husband and place limits on that. And by doing that, she was engaging in a conversation about what coverture looked like, what marriage looked like, what was appropriate behavior in her community. And then that was part of a tradition that became enforceable over time. And trying to convince people that married women in the late 18th and early 19th century actually had that legal voice, to me, it's an important thing to do because it broadens out what we see as our legal traditions, and I think in really, really important ways. And that moves beyond a top-down vision of the law. And I think that's actually really powerful and very empowering today.
Just to echo that, and that was beautifully said, I think history is just filled with examples in which the Supreme Court edict, was not the last word because people used other avenues. They used other institutions to advance alternative visions, so legislatures, agencies, political parties, social movements, right, all kind of offering their own understandings of fundamental rights and legitimate governance. And I think, to Laura's point, I think those understandings can be very powerful over time, even without the backing of the court. So an example that is salient to me with my own family history is the Korematsu case, which I would say was kind of overruled in the court of public opinion long before the Supreme Court purported to do so, because of these kind of alternative visions that people were pushing.
I think
purported to do so is good language. Sorry, go ahead.
Oh no, I was the question of should the Supreme Court be have the final word. I mean, I think no one has the final word on the narrative of American history, and that's as it has always been, as it should be. But obviously we're in the middle of a huge national and local set of arguments about how we teach American history and what constitutes American history. And in that context, I mean, I'll say something a little pessimistic, which is, I had the good fortune and the pleasure of teaching a class on the history of abortion in the United States at Northwestern last year, where we went through and kind of talked about the type of history on abortion that I was talking about people, getting abortions in the 19th century, the evidence that people continued to get them even when they were criminalized, and that the laws, the new criminalization wasn't particularly enforced or particularly popular, and so on. And then when we came to sort of reading the Dobbs decision, where the majority opinion says there is no history and tradition of a right to an abortion in the United States. Now, that right is interesting. I mean, arguably that there was no right in the 19th century for the reasons that Laura was just describing. But the reality, right, is not that people really didn't get abortions until, Roe v. Wade legalized them, right? The students were really dismayed that the court was putting forward such a sort of one-sided and inaccurate version of history. And they felt like this is a body that has enormous authority in the United States, and that for this history to be coming from such an authoritative place was, they were really taken aback, right? And they were really, they were happy that they had learned a different narrative, that they had learned that was not the whole story. But they were also like, well, how can this be? And how is this happening? The Supreme Court itself, of course, people are going to believe it if the Supreme Court says it. So I think it's really troubling. And I think that's one of the reasons we need to be having conversations like this.
Thank you so much. We're going to get to audience questions because we only have so much time left. The first question, what is the historical context and or precedent for, and I'm going to alter this a little bit, for changing the size of the Supreme Court? Nobody wants to take this one?
I mean, I actually don't know the answer to that. I know that other legal historians are very interested in this, and there's a kind of vibrant debate over, court packing or court reform. Yeah, I'm not sure what more to say that other than to say, we've thought about it a lot in the context of kind of Roosevelt's effort to potentially reshape the kind of the New Deal court before the sort of New Deal constitutional revolution. And I don't know that history has the answer to what we should do today, if that's the gist of the question, in the sense that I think today's Supreme Court is in some respects unlike courts that we've had in the past. And I think that has to do with the nature of the appointments process and so on. So this might be a place where I'm not sure that history is going to be our guide.
I will note that the Reconstruction Congress shrank the court to prevent Andrew Johnson from appointing anyone, and then expanded it again later. But the history of the court after Reconstruction is not a happy one. So I'll just point out that it didn't work maybe as much as the way that many of those legislators might have intended. For question number 2, do you think today's originalism or originalism in general would have allowed for segregation in schools?
I mean, this is a question that's often been discussed, because Brown v. Board of Education was the opposite of an originalist decision, right? It was a decision about what the United States needed in 1954. And famously, there was some historical research into the views of the 39th Congress and people surrounding the passage of the 14th Amendment on the question of segregated schools. And an example I know well from having worked on the history of DC, the same Congress that ratified or passed the 14th Amendment also approved of segregated schools for the District of Columbia. Actually, it was an improvement on the older order, because in the older days before that, there had been no public schools for Black children in DC. So now there at least were, but they were segregated. So the evidence that the framers of the 14th Amendment and people surrounding them were adamant advocates of school desegregation is not great. There were some of them who actually really were. There were quite a lot of them who were not. And so, Brown being sort of like the paradigmatic critical decision of the Supreme Court in many ways of the 20th century, people then went back, originalists, and tried to kind of retroactively figure out how they could make an argument, because originalists wanted to figure out how they could make an originalist argument that Brown was correctly decided. And I've read some of that scholarship, and it's a real stretch. It's a real stretch.
Yeah, if memory serves, and I could be wrong about this, but I'm pretty sure Bork said that you couldn't get there that way, and that was a failing of the and sort of acknowledged in the abstract that was a failing of the philosophy. But that has not slowed anybody down.
Can I just say one thing too about this question? I mean, I think there's a ton of academic scholarship on originalism, and there are kind of many varieties of originalism. So it's actually kind of a hard question to answer. And then kind of apart from the scholarship, there's the actual practice of originalism. And I think probably what all of us would say is that, judges sort of apply it in a way that's advantageous to them in the moment. So it's sort of an interesting theoretical exercise, but I think the judges who use it are sort of skilled at saying, well, of course, it would never require overturning, something that we all agree was canonically good.
Yeah, I think the paradigmatic example of that is Loving, actually. Obviously there's not a history and tradition of interracial marriage in the United States, so it's a little embarrassing to try and make an argument that then the Loving decision is correct, which obviously, very few people would want to overturn it. Fourth question, how much of an originalist were the original judges, for example, John Marshall?
So this gets back to Karen's point that originalism takes many forms, right? And so to ask if John Marshall was like Clarence Thomas is not, you can't draw a straight line between the past and the present in that way, right? So in the past, people actually followed precedent, right? And so you could say in a broad sense that that's kind of originalist. In that sense, law is kind of originalist in the sense that you are supposed to be following precedent and tradition and explaining when you're deviating from that. So yeah, it is interesting to me now that this idea of history as there's something fixed in the past that we can then compare to the present. It's becoming a way of understanding what law is. And I find that really interesting. It's how contemporary notions of originalism are now creeping in so that we ask questions about the past where it's really pretty anachronistic. And you can't really answer that question because John Marshall's just really not like today.
Did anybody else want to weigh in on that one? Okay. Question number 6. Does overturning Roe v. Wade also put in danger other laws such as the Americans with Disabilities Act or Title IX, I believe? Or is it Title? Yeah, I believe they mean Title IX here.
I think I could speak to this one. So I would say it doesn't, and it's sort of a different question. I think it's the question of sort of, there had been a prior precedent that said there is a constitutionally protected reproductive right, and the effect of Dobbs is to say, no, there's not. Oh, I'm sorry. My light went off in my office. And Dobbs was to say there is no constitutionally protected right, and thus the effect is to sort of kick that back to state legislatures, where they're then free to impose limits on what had been a right under the national constitution. The ADA, Title IX, these are statutes enacted by Congress. So it's kind of a different posture. But I understand, I think, the spirit of the question, which is to say that if something that we thought was sort of so settled, seems so consistent with our current understandings of inclusion and belonging, if that thing that we thought was so settled, is now up for grabs, what does this mean about similar rights? I think that's a good question to ask. I think probably the more apt worries would be, and this goes to Adam's point earlier, would be to constitutional rights that are protected in ways that Roe v. Wade had protected abortion. And so you can look at the Dobbs decision to see the different opinions in which the dissenters would say, of course, you're now putting up for grabs, marriage equality, the right to interracial marriage, like any number of the right to contraception, right? Any number of rights that you could say had been sort of protected similarly under constitutional doctrine, that Dobbs, with its kind of method and its reasoning, would seem to be put up for grabs. And of course, the majority says, like, no. And the concurrence from Clarence Thomas says kind of yes. But so anyway, my point would be, I think those would be the things that I would worry about more than statutes such as the ADA and Title IX. It's a great question.
Question number 7. Can you share more about women being able to challenge coverture laws?
This is right up my alley. So yes, in fact, we have a narrative in US history where you have this extension of rights to women slowly over time. And what this does is also project in the past. The further you go in the past, the worse it gets for women. And coverture kind of stands in for that. So coverture is this thing that is really restrictive in the past, and we've been slowly chipping away at it over time. And yet the history of women's subordination law is really complicated. Historians always say this, I realize, but it is really complicated here. And it's not a linear line of either progress or regress. And what happens in the late 18th century is you have a series of principles that are kind of loose things that are called coverture that don't quite fit together. So this systemic thing, coverture, which is oppressive to women, doesn't really exist in quite that way in the late 18th century. Some principles of coverture actually give women extensive rights to family property. They also open up ways that women can act in their husband's name and nobody asks, and so they end up acting on their own. And in fact, there's this whole range of legal principles that allow women all sorts of ability to do all kinds of things, challenge their husband's authority, control property, not own it outright. And this happens on an ad hoc basis. It doesn't happen universally for all women, but there are opportunities for some women to kind of push on some of these laws. And so that is happening in the late 18th century. In sort of the 19th century, we get a more rigid definition of coverture. And so the history here is uneven, whereby there's some space for women to act, not necessarily by using rights, but through other kinds of legal mechanisms. And then there's sort of a closing down later on. And it's interesting and important when you're thinking about originalism then, because it's like, as Karen has brought up, I'm sorry, I'm losing track here. As Karen, as other people has brought up here, that we go to a particular point in time, but which point in time do we go to? Because we're kind of all over the map here in terms of whether things are expansive for women or closed down for women, and that changes over time. So there have been all points in history where women have used the legal mechanisms available to push on their subordination. And frankly, this shouldn't surprise us. It's like with domestic violence, women don't like to get beaten. And so if they have legal mechanisms where they can challenge that, they generally did. So that kind of history, I think, is also really important, and understanding how people are pushing back, but also how these systems of subordination and restriction themselves change in their logic over time.
So one thing I'm wondering, originalism is presented as a judicial philosophy, but it's also, to some extent, certainly by the conservative legal movement, to be the only legitimate interpretive philosophy, constitutional interpretive philosophy. I'm wondering if the history and tradition language that we saw in Dobbs, does it bind non-originalist judges to do originalism whenever they issue rulings?
I mean, I think evidently not. I think it was Justice Kagan who said at one point, we're all originalists now, and sort of like the push to, if some people are going to be writing originalist decisions, then, people have to respond. And I think that's part of the occasion for this conversation as well, is that, as you said in the intro, this has invoked historians, right? It has invoked the professional expertise of historians. Well, what do people who, are professionally trained to do history and spend their lives doing it, what do we have to say in this context? But it's clear from recent decisions and, again, going back to the issues that I've been discussing tonight, that the dissenters are not exclusively writing in an originalist idiom. So we can think about Justice Jackson's dissent in the affirmative action cases, where it was actually Justice Sotomayor who wrote the more originalist kind of rebuttal of what Thomas was doing, while Jackson wrote about the continuing effects of structural racism after emancipation in a kind of it's very historical what she wrote, but it's not originalist, because she's saying, here are all the reasons why affirmative action, race-based affirmative action continues to be important and relevant for creating access for African Americans and other people of color in this country, because slavery was not the end of American racism. So that's one example. The dissent in Dobbs is another example that is not an originalist opinion, because it's saying we cannot look to a period when, just to give the ultimate example, when women could not vote. We cannot look to that period as to sort of know what we should be doing about gender and issues related to reproduction. So I think there is some of what you're describing of a kind of move to everyone kind of respond in kind, but they're also pushing back and saying this is not the only way. This is not the only tool we have. And there are many different ways of legitimately trying to judge and come to conclusions that are useful for us today.
I'll just caveat just one thing that Kate said, which I thought was beautiful. But I think an opinion like Brune actually does, I think, mandate that lower courts look at history and tradition, because it's basically saying, to what Laura was saying earlier, that this is going to be the way in which we decide whether a firearm regulation is constitutionally valid or not. But I think Kate's larger point was right on.
So, we've heard a lot of strong critiques of the originalism the court employs and its historical fixations. But I think it's also clear that originalism does not equal history. What positive roles do you think history can play in our understanding of the law, whether that's inside the courts or outside them?
I'll start us off. I will, for one thing, just echo what Laura was saying about the kind of the history, when done well and when done with kind of fidelity to the people in the past, who lived in the past, who experienced the past, brings to the table an array of sources that go beyond the traditional sources used in legal writing. And by that, I mean, constitutional text, statutes, and legal treatises, right? But going beyond that to look at the kinds of local sources that Laura was describing, or political debates about constitutional issues where the issue doesn't make it into the courts for a variety of reasons. And yet there's a large public discussion about, a particular question that eventually makes it into federal court. So, there's a way that historians can bring to the table a sense of the multiple ways that many people, not just Supreme Court justices, not just members of Congress, but everyday people contested the law and talked about the law and understood the law, that really is not tangential, but central to how we should be thinking about the kind of law in historical context today. So I think we really have tools that illuminate law in ways that we need right now.
So history provides wisdom, but it doesn't provide the answers. It's not like you can go to a moment in the past and, now it's all clear. In fact, at any moment in the past, there was a wide range of debate about what our legal traditions should be and what direction they should go in. And so if you go to any moment in the past, you have to look, as Kate is saying, at that broader conversation. And that conversation is not sort of ancillary to law or sort of outside law. In fact, the way that legal institutions were structured at the moment of our founding actually gave considerable weight to the conversations, the ideas, the opinions of people on the ground. And I think we're missing some of that right now in the originalist focus on particular kinds of text. And I think we're also missing that in our current understanding, because now we tend to see law top down. My students in my legal history class are very dutiful about, here's the law and we must follow it when the Supreme Court says something. And they don't realize that people didn't necessarily do that in the late 18th and early 19th centuries, all the way through the 19th century. People debated decisions after they were made, from the Supreme Court, but in state courts as well. After they were made, people sort of chewed them over and thought about whether they were actually going to do them. And those decisions were also in conversation then with a much broader array of legal ideas. And I feel like we can still do that today.
I think what I have to say will echo what Laura said. I think historians are really adept at showing how law plays out in the lives of real people and communities over time. And there can be a sort of, bottom up to top kind of messaging, because I think work in that vein can help lawmakers decide whether the law ought to be changed or whether some form of restitution or repair may be owed. I think historical work can also be helpful in surfacing alternatives to the current legal order, right? To the extent we're not happy with our choices today, history can help us see paths not taken, but that could still be fruitful, or modes of governance that have become unfamiliar to us, but might have lessons for today.
Thanks to everyone. Thank you to all of our panels for these insights, and for the audience for all of your questions. I wish we had time to answer them all. To stay up to date on more Brennan Center perspectives as these cases unfold, you can sign up for our newsletters. Sign up for the briefing newsletter at brennancenter.org/briefing. And the Brennan Center looks forward to seeing you at future events. And keep an eye on brennancenter.org/events to learn more. I'm Adam Serwer. Thank you all for coming.